Hi, folks. Greg Siskind here, and joined by Lynn Susser and Jeannie Santos from the firm. We didn't give you a lot of, well, you should by this point have figured out when we do these things, but I didn't do any promoting or anything online. So hopefully you're either new to come to the regular places to find us tonight, or you have randomly stumbled into us. And if so, well, either case. So we have quite a few things to cover. I did want to mention one thing before I forget later. Well, actually, I'll mention it later because usually people start a lot of people start joining. But then I'm going to mention that the big case management survey, because I know there's a bunch of lawyers that watch this. Anyway, the courts are where all the action is this week, wouldn't you say? And Jeannie, I know you. We talked earlier, and we queued up a bunch of things that are going on in the courts, including our own case, which we'll talk about at one point. But where do we start tonight as far as the litigations that's going on in the different courts on the different issues?
I think maybe since there were oral arguments today on the birthright citizenship case.
It's tomorrow. I was wrong on that. I thought it was today. It was tomorrow on there. I was like, why isn't this in the news? And I was realized because it's the 15th and today's not.
Well, good. Then we'll preview.
I was thinking all day today. It was the 15th and it was the 14th. Anyway, it's tomorrow. I think with the Supreme Court, you can listen. You can't watch it. And I don't know if you can listen live, but you can listen to the arguments. I don't know if I think they post them after, but I am not 100% sure on that. But you will.
There is a way to listen to it, maybe through SCOTUS blog or something. I think there is a way.
Well, SCOTUS blog is like blogging when it's happening, and they're talking about what people are saying. I'm not sure you can actually listen live there, but that's a good place to go to for people that want to kind of follow what's being said about it. But so tomorrow, basically, this is not the big argument on birthright citizenship. This is the question about whether whether this national injunction will stand, or they will lift it and have and allow this executive order to go into effect. I have a feeling they're not going to, even if they think they might later on, gives a serious look to overturning, which I don't think they will. But even if they did, there's a lot of reasons why you wouldn't want to let this go into effect immediately, just because of the massive chaos that I think it would create in terms of figuring out how to apply it for all these children who are, I guess, born after the thing takes effect. So that's going to be that's tomorrow. My guess is, the one thing, and Chuck Cook, my friend and our litigation colleague, he thinks really what they're interested in doing is somehow limiting the ability to do national injunctions. And if that were the case, there are 4 cases around the country, but that in theory they could say, we're not going to overturn those injunctions. We're just not going to. I mean, we'll allow those injunctions to stand within their jurisdictions, but that would also be really chaotic. All of a sudden, you had all these rules for, depending on which state you're in, whether you have birthright citizenship or not. That's also quite chaotic. So I can't see them doing that. But in the end, they may do something to try and, in future cases, make it more difficult to do national injunctions. We also thought that that's something that the administration would not want, because I think they just want a rule that this injunction is not appropriate, but they don't want any kind of bar on national injunctions, because they have benefited significantly from those injunctions, particularly when they were suing in the Biden administration. My guess is they don't want to lose that, because they basically have a couple of go-to judges, and if those judges can't do what they need them to do, they're going to be and have a much tougher time pushing their agenda. Then you were about to say something?
No, I was just asking if tomorrow the hearing is only on whether or not the injunction will stay in place. Do you know whether they've scheduled oral arguments on the actual substantive executive order for this term?
No, I don't think they have. So, I don't think that it's gotten that
Yeah.
far yet on there. Tomorrow, the only question is about whether they're going to pause the policy while it's being challenged in the courts. But
Right, because the underlying case I don't think has been heard yet, right, by any court.
I mean, I can see. Look, my guess is if they take it, they will try and time it so that it will be a decision probably next summer, where they can have proper consideration for it and all that. But basically, we're almost at the end for this session of the Supreme
Right.
Court. So, and I think they have to do. I mean, they really have to do it that way because they've had at this point in the courts are injunctions and TROs. We haven't had an actual substantive trial
Right.
yet in the lower courts. So I don't think the Supreme Court's going to do anything like that. But my guess is that will be the summer of 2026 blockbuster decision that we're probably going to see. There may be some others. Alien Enemies Act and a few others are going to go eventually work their way up to the Supreme Court, where there will be proper oral arguments and briefing and all of that. So right now, this is just all about the whether these executive orders can take effect or not.
Yeah.
All right, stay tuned on that.
Yep. So speaking of the Alien Enemies Act, we did have a decision from a district court judge, basically allowing the Trump administration to use.
I mean, there have been 4 cases, I think, where judges have been. I know there's one in New York, there's one in Colorado, and one other. But basically, this is the first judge that said,
Texas.
"Yeah, I think the Alien Enemies Act is a thing." On there, she still said that it is a Trump nominee that was the judge in the case. So, not a total shock. Even though I know you're not supposed to sort of presume judges do. We've had judges appointed by Trump who've been great in our cases, but in this case, it would have surprised me a lot more if it was a Biden appointed judge than a Trump appointed judge. So I'll leave it at that. But basically, this is the first judge out of the 4, I think, that have issued rulings on this, and the others were New York, Colorado, and Texas, which actually said the Alien Enemies Act might actually apply here. But she's still giving the potential deportee 21 days to contest the removal. And I guess basically, though, the way she's leaving it is they're not going to be able to contest removal based on the Alien Enemies Act. They're going to saying that that's not properly used here. They're just going to have to say it doesn't apply to me because I'm not an alien enemy. I'm not a member of this gang. I'm not whatever the issue is. So that's really, I think, that what the big difference is in these other cases. These if you went on it sounds like the administration is going to have to prove the Alien Enemies Act is real, even if somebody is in one of these gangs and all that. They would still have to be put through normal removal proceedings. In those other cases, here, I think if the government can convince the judge that they're in that group, that gang, I think she would be content with allowing removal under the Alien Enemies Act based on this decision today. If you could disagree with that, let me know.
That's what it sounds like.
All right, Jeannie, what's next?
Let's see. Well, we were talking earlier about a federal judge that threatened the Trump Department of Justice with contempt for the Kilmar Abrego Garcia case because they're not, really.
She's not messing around.
Yeah. Well, they're not helping facilitate his return as she ordered.
Yeah. This is Judge Zinnes. So, Lynn and I were just talking about this before the call and looking back over what happened today and or happened yesterday. But basically, there is a privilege log that explains how they're using state secrets in the deportation case. This is Kilmar Abrego Garcia. Everybody, it's been in the news. The fellow who got sent to El Salvador. But
got illegally sent to El Salvador after an immigration judge said he could not be removed to El Salvador.
But anyway, the government was not producing this document that the judge wanted, and she apparently was not happy, and she told the Justice Department that they had 30 minutes. This is on Tuesday, yesterday actually. They had 30 minutes and said that their silence was an intentional refusal to follow a court order. So basically, if I
They
think
were going to be in contempt if they didn't do
they
it.
were right. She was going to call the marshals if they didn't have that document available to her in 30 minutes. I think they took like 32 or 33 minutes. I think that they deliberately take an extra couple of minutes to show them who's the boss. Not the
Hopefully
judge.
she'll show them who's the boss.
But anyway, that happened, and so far nobody in the administration has been held in contempt. That's like a big surprise on there. They've certainly, I think, tested some of these judges in these cases, but although on the other hand, we haven't had anything as brazen as we did on that case earlier, and brazen as we did on the with Judge Boasberg earlier as well on the with the plane. When they told the plane to turn around. So we will see on that. But that's that case is alive and kicking, and we'll just have to hopefully see if it where it goes. All right, Jeannie, anything else on the courts?
Well, I mean, this one for me hits home because I'm from Wisconsin. So there was a federal judge who, in April was arrested for supposedly helping an undocumented person to evade ICE. And she was indicted by a federal grand jury.
Yeah. I mean, on that one, I was pretty indignant a couple of weeks ago when I was talking about it. The more I've read about this case, it's like,
I think there's more to it than what we understand just from the newspaper.
I mean,
probably, maybe not, but
I don't know on here. I mean, if she just told people that you can exit out this way, and sometimes people exit out that way, especially when there's a big commotion going on in the hall on there. I mean, sometimes there's media in the hall. There's crowds of, out in the hall for high profile cases. And sometimes a judge will tell somebody to exit out of a certain, out of a side door if she's concerned about that. So, I mean, there might be an explanation for it. But she is, she's facing some serious problems on there. So, and a grand jury indicted on there, which means it wasn't just Justice Department lawyer. I mean, it was actual people that had to hear the facts of the case. And I don't think it was super complicated. And I think most people on that grand jury probably knew all about that case from the news. So that leads me to believe that even though grand juries, as they say, grand jury will indict a sandwich. What's the old expression that, and grand juries in some places have like 99% indictment rates for what's presented to them. So because the prosecutor really controls everything about that, what's seen on there. So it's not like the person that's being indicted has any defense or anything like that. And it's very possible as well that she didn't testify. So everything that was heard by the grand jury was exactly what the Justice Department wanted them to hear. So maybe you can't read that much into it, but I hope she has good lawyers. Okay, and we also had this Newark mayor also got into some hot water on there, and I didn't follow. Did you follow that case that closely?
The Newark mayor who got arrested for, I think all he was doing was participating in a demonstration.
Well, yeah, I mean, they were asking to
at an ICE facility.
They were in an ICE facility.
Yeah.
They apparently, whatever happened outside the facility.
Yeah.
On there. So it seems like this is all, well, either it's a misunderstanding or this is just done to embarrass the politician.
Yeah. I thought it was a bad look for ICE to.
Yeah. ICE has a lot of image problems right now. That's not going to help them on there. I'm not sure. I mean, I think a lot of times they have a lot of own goals where they make these mistakes, like in our case with the students. That blew up in their face in a big way. All right. So I think we've covered the cases, Jeannie. A very there was the IRS case. We didn't talk about that.
Oh,
So
right. Yeah.
yeah, and the IRS case, this was the one where the administration said that USC said the immigration agencies can base that the IRS has to provide information to the immigration agencies on anything that's in IRS files. That was pretty.
Well, right. I think they ordered the IRS to do it, and the tax commission, didn't the commissioner like resign?
Yeah, the commissioner resigned. It was a big thing. Anyway, there was a lawsuit that was filed almost immediately after that happened, and there was kind of a mixed decision that came this week. I don't think it's great news for the administration, but basically the judge said yes, there can be information sharing, but he limited it to just people that have already been ordered removed or people that are under some kind of criminal
investigation
by DHS. So that really limits greatly whose information can be shared.
It means that there won't be any massive turnover of information of people who are
guess
undocumented who are filing their taxes.
You would think if somebody's already been ordered removed, they're on very shaky ground. I would bet there's not that many of those people that are actually paying taxes that they've already been ordered removed.
Well, even if they are, like, that's the least of their problems, I think, at this point.
Well, the only thing I could think of is there are people who are deported in absentia. We had a case, I remember a couple of years ago.
Well, that's true. And a tax return could tell you where a person was.
Right. We had a case where somebody was applying for a marriage-based green card, and they went for an interview and only learned at the interview that there was that they had an order of deportation in another state that they had moved from. So there are those cases where people genuinely have no idea that they are already ordered removed. But I still can't believe that there would be that many of these people in that situation. But in any case, that's where this case stands for right now. This is just the preliminary injunction part of it. As in almost all these cases, none of these things have actually had real trials yet. Yeah. They're all in these preliminary stages. So, so that order can go forward, but in that very limited way. And that, I think, that's probably really it for the cases, right?
I think so.
I think so.
But there is other news. We had the announcement 2 days ago that TPS status for Afghanistan, the administration is going to request that, or that they're going to terminate it effective July 12th, which I guess is the end date.
It's probably the end date of the current period, yeah.
For it. I will say that regarding TPS, a lot of people sort of make the incorrect assumption that because the president has really broad discretion to grant TPS to a country, that it's super easy for the president to take it away. And that is not the case. That there are all sorts of requirements basically the president has to demonstrate that the need is no longer there for TPS for that country. So the burden is going to be on the administration to show things are really great in Afghanistan. There was a lawyer yesterday when I was posting about this who was, who's very knowledgeable, and he was talking about how things really are not as bad in Afghanistan as they were in 2021. But I think they're going to have a really hard time convincing a judge that it's safe for, especially for a lot of these people who have TPS that were the ones that are here are typically not sort of your average people. They oftentimes had roles assisting the allies, or people that were academics, people that would basically not typically, you wouldn't expect to be treated well by the Taliban if they go back. So my guess is that we haven't seen a suit yet, but we're probably going to. Well,
it's probably going to cause a big uptick now in asylum claims by Afghanis. If they haven't already applied for asylum, they'll have to apply now.
Yeah, that's the, so certainly that should be the case for anybody in these categories, the parole categories and TPS categories that are being eliminated, should be thinking about making asylum claims, even for the cases right now where there are injunctions that are stopping the administration from proceeding.
Right.
Those can still, those injunctions can be overturned, and at the appellate level, the administration could win at trial. They could win on the, beyond that, even if they lose a trial, they could win on an appeal. They could go up to the Supreme Court. There's a lot of reasons why you shouldn't assume that just because you're safe today that it's necessarily not going to be always the case. So you should be talking to counsel if you're in one of those categories that was being eliminated, that has been saved by a preliminary injunction or a temporary restraining order.
The other thing I would say about that is that, if you want to apply for asylum and you just read, that you have to apply within 1 year of arrival, people should know that if you have some other kind of status like TPS, or you came in as a visitor and then you applied for TPS, or you were a student and then you applied for TPS, the 1 year rule doesn't apply. And so for those of you that have TPS now, you really should, the 1 year really won't start until TPS ends. So you should talk to counsel and see whether or not you have a viable claim.
Right. All right. That was sort of the big policy news of the week on there. There was something that was kind of an interesting, another case of a permanent resident who was thrown in detention. And this one was a little bit of a surprise. It was a band member for a rock band that was leaving the United States.
Oh yeah, that's so weird.
In Europe. And that's the first case I've heard of where, there have been a couple of instances where permanent residents have been denied re-entry to the U.S. And there have been some cases where permanent residents were picked up by ICE, like the Columbia student. This is the first one where somebody was actually detained when they were
way out
to the United States. This band was on a plane and they were headed to Europe for a European tour. Presumably on the way back, they would have done the same thing when this person was coming into the country. But it is a little bit of a shock that we don't know enough detail. Like, was it flagged by TSA in the computer, or were they already knew? They already had the list, I guess, is submitted a couple hours ahead of time by the airline, the manifest. We don't know the details of sort of how it happened, but it did. We also don't know why he's been.
It just happened, and the article said that even the band members weren't even sure where he was. They weren't sure what was happening yet. Like, they were just trying to figure it out.
Right. And that's the big problem, I think, with this whole thing about detention is a big problem, but it's even bigger because they withhold information from family members and from friends what's going on, and makes it very difficult for a person even to have legal counsel. People can't figure out where they are, and apparently they're not giving them access to phones and other things, which, I'm hoping that a court will step in and basically say these are the minimum things that you have to do if you're going to even try and do that, just because in a lot of these cases, permanent residents should have more rights on there. You could say one thing about somebody that was, coming in on a tourist, even though in those cases they honestly should just put people back on airplanes, but actually depriving somebody of their liberty and putting them, and they would claim it's not really prison on there, it's just detention, which is not really jail, even though it is jail on there. But
it's real bars.
That's something that we have not seen the courts clamp down on that practice yet, and hopefully that's something that we're going to see.
And I would also just mention, while we're talking about people getting stopped on the way out, going out of the United States, we've also heard reports that CBP is stopping people that are taking the bridge from El Paso into Ciudad Juarez, and that those and the only ones we've heard about, the couple people that we heard about that were stopped and turned around, they were trying to leave, they were undocumented, they were going to Juarez for immigrant visa interviews. anyway, it got sorted out after a few hours, but we've been sort of telling people like maybe just stay away from that bridge for now and find a different way to go back into Mexico.
Okay. All right. I promised folks that we would talk a little bit about the case that we're working on with Impact on the F1 students. So that case is pending. That amended complaint is in the District Court of Georgia. I will tell you that case originally started out as Chuck Cook filed the initial version of that case for 133 plaintiffs. He already received a temporary restraining order and a preliminary injunction requiring restoration for that 133 of those people's CVIS record. By the way, I'm was arguing with Chuck yesterday on a CLE program about whether it's CVIS or SEVIS. Everybody in the university communities that I know call it CVIS, but maybe I'm not sure there's a correct pronunciation.
It's an acronym. It's not even a word, so I don't think there can be
I call it CVIS.
pronunciation.
I've always heard it called CVIS. In the J1 world, we call it CVIS. I wrote a book on J1 visas that say, and I've always known it as CVIS. And then all of a sudden, when this stuff started happening, I kept hearing people that I know don't do that much work in the J1, M1, and F1 space calling it SEVIS. Anyway, I know Erin Hillis is here. I'm curious if there's any other DSOs that are here and what they call it. But anyway, so we filed that case, and we have, I can't tell you about some things that are going on in that case that are good things. But I can tell you that if you are in that case, that you're one of the plaintiffs, please check your email. We are needing your CVIS number. If we and we need it for every single plaintiff in that case. We don't have it for about out of the 350. We are still needing it from about 100 people. So please get that information to us. Fill out that little Google form that we sent you. That's all we need is your name and your CVIS number. That's it. Yes, thank you. Erin says I was pronouncing it correctly. If you look in the comments, she says SEEVIS. So that's but we for that case, basically there's sort of two parts to it that we're trying to deal with. One part is the CVIS part. And in that case, there's a couple of issues. One is obviously we want everybody reinstated. Some of our clients have been reinstated. Some of them have not been reinstated. Some of our clients were reinstated and then they got notified that their visa was revoked after the reinstatement happened. And then ICE went ahead and revoked terminated the CVIS again on there. So that's, which is what we were predicting was going to happen after that memo came out, where now all they're trying to do is basically change their policy, say that they're required to revoke CVIS, to terminate CVIS if a visa is revoked. And then magically the visa gets revoked when ICE communicates with them that they spotted something in the system. Why are they doing that? Because the administration believes that it is much harder to appeal something that the State Department does than something that ICE does. So if the State Department is at the heart of this and they're causing the problem, and ICE doesn't have a choice, so they say, based on this memo that they created without following anything in the Administrative Procedures Act. So anyway, it's not a winning strategy for them in our view. But that's so that's part of it is that, and is getting it restored. The next part of it is getting it getting retroactive application. In other words, people who have their CVIS status restored are still potentially in trouble because they have this gap in their record, which could potentially prevent them from doing certain things that they want to do, like applying for OPT and other things that they need to have a clean record for. So we're asking the government to retroactively reinstate the status so that there is nothing negative in their record. The other thing that, and also we obviously want to make sure that anybody who's in this situation can't be put into removal proceedings because of any potential violation that happened, even if it's been corrected. All that being said, there's still this big, gigantic problem, which is visa revocations that have happened. And one of the differences between our suit and some of the other suits, well, I mean, aside from the fact that ours is seeking class action and is involving a much larger number of people than the others, is we are suing the State Department as well as DHS. The State Department, our position is that consular non-reviewability, which is what the government is going to argue, is what, that you can appeal a visa revocation. And that we believe that that only applies for when an individual visa officer makes a decision on an individual case, and a judge can't go back and overturn the decision of an individual consular officer. In this case, these decisions were driven by officials in Washington and not the consulates, and they were done en masse and not on an individual basis. And we don't believe consular non-reviewability covers that situation. And also, it doesn't cover situations where there are constitutional violations that are happening, and we believe there have been due process violations as well. So we have some pretty good theories, I think, to challenge the State Department. I don't want to be, I want to be realistic that it's hard to sue the State Department, but we think we have we think we have some pretty good arguments, and hopefully, I mean, ideally, the State Department will just fix this problem on their own when they rather than actually because if we get past the first round and we start getting discovery, I have a feeling there's a lot of documents out there that are going to not be a good look for the State Department when it comes out. The whole story comes out on how all this has happened. Eventually, it will come out how this happened, but that's not something I think that at this point they're going to be super excited about having to do. So that is that's Doe v. Nome, our case there, and we hopefully will have some news on that in the next couple of days.
Awesome.
All right, Lynn, you wanted to talk about adjudication trends and things like that.
Right, I did. And the other thing I want to talk about before we finish is just if there was any change in the visa bulletin, which I think Jeannie looked into. So yeah, just on adjudications, just a couple of things have happened. I mean, the good news is that for most part, USCIS adjudications are moving along business as usual. We're seeing a few little slowdowns in a few places, but basically so far so good. Nothing dramatically different. The only thing that's happened that's weird is that in the last few weeks, and we haven't had any cases like this, but lawyers are reporting receiving RFEs and I-129, so basically H-1B cases and I-140s, getting RFE notifications saying that there's been some sort of adverse information found in a person's file and therefore sending them for biometrics. Now, in some cases, when they go and get the fingerprints done, they're just getting an approval right thereafter, which leads us to believe that probably it wasn't even them that the adverse information was related to, because keeping in mind that when someone files an I-129 or an I-140, there's no fingerprints involved. So some of these things may be popping up and not actually be related to the same person. In some cases, lawyers reported that after the fingerprints were done, they received a second RFE asking them for court dispositions to sort of clarify what might have happened. We have not heard any reports of any denials after these yet, but I think the lesson learned here is that if you get such a notification, like, you need to talk to your counsel and figure out like what's going on that might have made you, might have made them suspicious or want more information. And, if you can't think of anything, maybe it's not even you, but that's just something that we're seeing. The other thing is
Lynn, if somebody gets that, I mean, if they get that biometrics notice, when we were talking before, they should. I mean, if they don't have counsel, they should certainly talk to counsel about it.
Yeah, right. I mean, in most cases, right, it's the employer that filed the petition, but it's going to be the individual beneficiary who's getting these notices, or they're coming in the context of an RFE, is what I'm understanding.
Yeah.
The other thing that's weirdly happened in the last couple of weeks is we're hearing that lawyers have received RFEs asking for the wet signatures from petitions that were filed. So this goes back to the COVID days. In the early days of COVID, USCIS created several different workarounds and accommodations for people that were working remotely to be able to file petitions. And one of them was they waived the requirement that in those days that everything had to have a wet signature on it, an original wet signature. And they allowed us to start filing petitions with copies of wet signatures. In other words, our clients would sign, and then they would email us a copy, and then we would use that. And after the pandemic ended, they made that rule permanent. And so many petitions are filed, most petitions probably these days, with a copy of a wet signature. Well, and the original rule did say that employers should keep the original page they signed in case it was requested later. But we've never in all these years heard of them being requested. And evidently suddenly people are seeing requests. So the advice is that if you are an employer signing off on one of these petitions, just keep the signature. Yeah, keep the original signature page that you're emailing back to your lawyer for them to submit, so that if USCIS asks for it later, you'll have it.
Yeah, all this is ridiculous because we should have e-filing, and we shouldn't have to actually have wet signatures and signatures at all. We should be doing everything electronically.
Yeah,
but yeah, anyway. I was on a call today with someone who is involved with a lot of the electronic filing initiatives from the Biden administration, and they were really close to actually having all kinds of things like PDF uploads and all kinds of things that would make, and having G28s on all the cases where you could file it. It's and the impression I had was that they sort of left everything in a place where the new administration can, if they want to go forward with all this stuff, they can claim all the glory and everything like that, because they finally are in a position now where they can where they could really take it to where everybody wanted it. But it's sort of anybody's guess right now what the administration's plans are.
Well, I don't think they're going to do anything right now that's going to make it easier. They're looking for ways to slow things down, and these are like sort of low-hanging fruit, I think.
Yeah, well, that's true. On the other hand, there's a lot of people leaving the agency. They need to probably figure out ways that they can do things with fewer people. E-filing is very doji on there as far as like cutting expenses, cutting a lot of employees.
Right. I think that the e-filing system for the things that you can e-file, like I-130s, I-90s, N-400s, those things, I think they're pretty popular and everyone's using them. Unfortunately, the system, the way they set it up for I-129s for like H-1Bs is not great yet. It's a little bit limiting. So I think most people aren't using it yet, or they're using it in very limited circumstances.
Yeah, I mean, I think the, and you and Jeannie sit in the flag system a lot more than I do, and also with the DOS systems, and USCIS has sort of been the odd man out as far as the lousy e-filing. But it is they did do a good job with the H-1B lottery this year.
Yep, they did. It went off without a hitch.
A lot of people gave them a grade of A for how smoothly the lottery went, probably more smoothly this year than it has in years on there. So that was all. And so Trump's USCIS can claim credit for a very smooth operation. With that, I hope that there shouldn't be anything really partisan about electronic initiatives at the agency. So if there are any USCIS people listening to this, please continue on. It didn't start in the Biden administration. A lot of his stuff started in the Trump administration. Francis Cisna promised that we were going to have a completely electronically filed system for all our cases by 2020. So the first Trump administration was working toward that, and I hopefully that it's, even though the Biden administration made a lot of progress in that regard, that it's not seen as something that they need to stop all progress on that because Biden was the last person to touch the immigration system. A lot of stuff that Biden was doing had been started in the Trump administration as far as that goes. So we shall see.
Yep. Jeannie, tell us what's going on with the visa bulletin for June.
Yeah, so we did see some movement forward for June in some employment-based categories, basically for China and the rest of the world. Unfortunately, nothing advanced for India. So I won't go into finite of detail, but
anything go backwards?
It stayed the same, no change.
Okay. No reservation.
Yeah. So, for example, EB2 China advanced 2 months to December 1st, 2020. So there's something, and EB2 rest of the world advanced just under 4 months. So there was some good movement to October 15th, 2023. No change for India in EB2 or EB3, unfortunately. China also advanced 3 weeks in the EB3 for skilled workers and professionals. No change for the other workers. And the rest of the world, skilled workers and professionals in the EB3 advanced 5 weeks to February 28th, 2023, and other workers advanced a month. So there was some similar movement in like final action date chart and the date for filing chart. Slight differences in how much they advanced in those same areas, but fairly similar. So that was some good movement forward.
Yeah.
Something anyway. It's always good to see something. For final action dates for the family sponsored preference cases, there was some movement also for not for Mexico, for example, but in sort of the rest of the world. F1 category moved forward just under 3 months. The F2B category moved forward 2 months, and also F3 moved forward just under 3 months. So, something there. But
that's good.
Yep, I think that.
I mean, it's positive. I was telling clients I didn't think we were going to see much movement in on the employment side until October. So that's actually, it's kind of nice.
Yeah.
I was happy to tell a few clients today that their dates were current for next month.
It's always fun.
Yeah.
All right. Well, we will take questions if there are any. Otherwise, we will call. It is May, and this is the time of year where classes get dismissed early, and offices close early in the week. So we'll dismiss class early if there are any questions, which I'm not seeing yet tonight. But hopefully, when we report next week, we'll have. We'll talk a little bit about this Supreme Court argument. I know that is freaking out a lot of people that are in the non-immigrant community because it affects non-immigrants whose children are born in the United States and not just people who are without immigration status. So we'll talk more about that. And I believe I'll have some significant news on our case, one way or the other, on that next week as well. So. Oh, Erin has a question. She's curious what happens if people don't comply with the Supreme Court or lower court judgments in orders of contempt in court. Well, so
Good
that's
question.
the thing. We have nobody, right? So I will say, I mean, there have been instances in the past where people got close to the line where they had a claim that the decision was not what everybody believed the decision was, and the decision was something else, and eventually the court had to step in. But when if it crosses that line and a court order is just ignored completely, we don't have separation of powers anymore. We don't have rule of law. I'm hopeful that if that did happen, at that point Congress would step in. And the courts would become more forceful, and that people in the administration would stop following orders necessarily they're coming. But it is a good question. It's a question a lot of people have been fearing. We have had a few instances where there was a defiance of a court with only for it to be backed down or for them to later on say, I didn't think that's what you meant. Basically become the defense when that happened. So it's a good question, Aaron. I think we're in big trouble if that becomes a trend.
Yep.
All right. Well, thank you guys, and we'll see you next week. And maybe we'll have some good news to report next week. You never know. It's not always bad. Even though it's mostly bad.
You're the optimist.
All right. There you go.
Good
Bye-bye.
night, everybody.
Good night.